This is the fifth meeting of the Bills Committee on Mandatory Reporting of Child Abuse Bill. We have a quorum. I'll call the order to meeting. This meeting is scheduled to run until 11 a.m. As the chair of this committee, I'll have to let members know about the procedure of our meeting. This is the fifth meeting. In the previous four meetings, during three of them, we had public hearings. We invited professional groups and bodies to share their views. There were about 80 groups and professional bodies that attended the public hearings. We spent a lot of time on the public hearings. Every time the professional groups expressed their views, I allowed time for members to voice your opinions. So we spent a lot of time and attention on the work of this Bills Committee, so I'd like to thank members here. Last Saturday, we completed the last public hearing. We invited representatives from the healthcare sector to attend the hearing. And within a week's time, we're holding this fifth meeting. This is because we have listened to views from the relevant sectors, and we want to make good use of our time to consolidate the views that we had heard from the relevant sectors as well as our views. We want to have time for the administration to clarify on these views. Also, LegCo is busy in December, so it may be more difficult for us to schedule a meeting in the latter half of December. So we scheduled a meeting today, and this will be the only meeting we have this month. Our next meeting will be held in January. The administration will tell us about the works that will be carried out in 3 stages. These work carried out by them will be in tandem with our work during the Bills Committee. Again, I thank members for your participation. The goal of today's meeting is to have a discussion on the views that we have heard over the past meetings. Prior to this meeting, I got views from Mr. Dennis Leung and Mr. Teck Chi Yun. They have their views on the bill. And for members who have made submissions and issued letters on the bill, I'll ask them to talk about their submissions. After we have had the relevant discussions, if members find it appropriate, we may proceed to clause-by-clause examination of the bill. As the chairman of this committee, I think that, say, if the administration can provide the relevant information we ask for only in January, then we can still proceed with the clause-by-clause examination, and when the information is ready by the administration, we can make a pause and look at the information provided. This is a new bill. We will look at the wordings of the bill. It does not only involve legal issues, but also policy matters. So we will work towards this goal. And as mentioned, the government will conduct consultation while we have the Bills Committee meetings. We will hear from the government if they have any updates on the progress of their consultation. Let me first invite Mr. Ho Kai-ming, Undersecretary for Labor and Welfare. To talk about the views that we have heard in the public hearings, as well as the progress of formulating the reporter's guide. Mr. Ho. Thank you, Chair. I thank Chair and members for scheduling the 3 public hearings on the 12th of September, the 10th of November, and the 25th of November, so that we had an opportunity to listen to the valuable views as well as the chance to tell you about our views. The purpose of this bill is to create a wide protection web, and we want to send a clear and strong deterrent signal to perpetrators. We noticed that the social welfare sector, education sector, and the healthcare sector in general support the establishment of the mandatory reporting regime. However, they have some concerns. This include having to include relevant stakeholders when we formulate the mandated reporter's guide. And they want the guidelines so that they know how to identify suspected abuse cases. Some of the mandated reporters, they do not know that they can actually make reports now, but when the bill is passed, they will be required to make reports. It seems like they are not very clear about this. Also, they want to make sure that there is enough manpower to handle the substantial increase of reports that will be received after the bill is passed. They also want professional counseling for children, and they also want enough space to take care of children of suspected child abuse cases. We have done the following work to address the concerns. First, on the mandated reporter's guide, we are now at stage 1 of the formulation. The stage 1 will complete by mid-December. Education Bureau, the Labor and Welfare Bureau, and the Health Bureau will work with the professionals of the relevant sectors. We discuss with them the possible scenarios they may face, as well as the reporting threshold, so that we have a basis for our discussions of the bill. As mentioned, we'd like members of the relevant sectors to provide more of these real-life scenarios to us. So we appeal to members of the relevant sectors to share their experiences and cases with us, and we'll have a focused discussion on these cases. So during first stage, we are collecting these views. In the second stage, from January to April, we will set up 3 professional consultative panels comprised of representatives from the government and relevant professional bodies. And we will, based on the views that we have collected during stage 1, have focused discussions during stage 2. We'll formulate the reporter's guide, and we will report the progress of our formulation of the guide to the electrical. We're now working on the list of members to be included in the panels. For the third stage, after the Bills Committee has finished the scrutiny of the bill and the third reading of the bill at LegCo, then we'll come to the third stage. From the Gazetted to the operation of the bill will have 18 months of transitional period. We hope that we will be able to finish the guidelines by the end of the 18-month period. We understand that the relevant sectors want us to make sure we hold training for the relevant personnel. We're now working on an electronic platform or an e-learning platform to help the relevant sectors to identify suspected cases. There are 2 modules. They cover basic knowledge of child protection as well as basic knowledge of relevant legal and reporting issues relating to the regime. We hope that by Q1 next year, we'll be able to roll out the first module. Module 2, depending on the progress of the legislation, we will, by end of 2025, hold briefing sections. We must be able to do that by 2025. Depending on when we pass the bill, we will roll out Module 2. It will include contents of the bill or the relevant legislations. The relevant departments and bureaus of the government will provide the relevant sectors with training sessions on e-learning. We'll also make sure that we have enough manpower. For this financial year 2023 to 24, we have put in an addition of $24 million, and we will create 40 plus permanent posts to handle the potential increase of reports we receive under the mandatory reporting regime. We'll also step up enforcement of law. We will arrest perpetrators and conduct investigations. We'll also do follow-up work. We will, for the relevant professional practitioners, provide training and step up education and publicity work. Also, we will provide additional support to children in child abuse cases and their families. We will have home-based orientation and clinical supervision. Based on the difficulties, we will provide the relevant support and we will educate parents about positive parenting to help them rebuild their relationships with their children, to minimize their chance of abusing their children again. Also, we will provide emergency placement services for children. We have increased the number of emergency service places. We are preparing for another residential child care center apart from the one that we are going to set up now. There will be an addition of 96 service places, and for each place, there will be a 3-month turnover. We will be able to provide emergency placement services for 384 children according to our estimates. We'll also step up training for foster parents. Next April, the Social Welfare Department will substantially increase the incentive payment for foster parents. For normal foster parents, the incentive payment will be increased from 5,000 to 11,000. For foster parents providing emergency services, the payment will increase from 6,600 to 13,000. We will also arrange for assessment as well as treatment for children in need.
興趣班等等。There will be extra allowances for foster families with children with special educational needs that will cover extracurricular activities. The government will continue to listen to members' views attentively and fully work with LegCo on the scrutiny of the bill. We want to see the early passage of the bill to take this first step, a key step in protecting children. Members, we had 3 deputational hearings. 8 members, including me, asked the Secretariat to invite submissions. We invited deputations from the education, healthcare, and social welfare bodies to attend. 78 representatives attend, and we have 52 written submissions. Out of them, 6 written submissions involve bodies that did not attend the hearings. We had the hearings where we heard the concerns. Members may have further questions for the government based on those concerns that we've heard. Before we get to the questions and answers, a question for Mr. Ho Kai-ming, Undersecretary. For the 78 groups that put forward their views and the 52 written submissions, when can the government collate those concerns and offer a consolidated written response? Chairman, the last public hearing took place last week. We're still getting further submissions from the healthcare sector. We want to be able to offer a consolidated response by the next meeting. So let's wait for a bit, wait till we get all the submissions from the healthcare sector, and then we will come up with the written response. I believe members have questions based on the deputation's concerns, so I won't propose to try to summarize their concerns. If members wish to put questions, please raise your hands. Ms. Doreen Kong, Dr. David Lam, Reverend Peter Kun, Ms. Connie Lam, Mr. Lai Tong Kwok, Mr. Dennis Leung, Ms. Elizabeth Quat, Five minutes for each member. Do we have a timer? Yes. Ms. Doreen Kong. Good morning, Chairman. I'm pleased to see that you are not rushing to the clause-by-clause scrutiny. I did not attend all those public hearings. I attended 2. The bodies that attended the hearings gave us great comments. The government should consider the considered comments from those bodies. The system is back online. If you wish to put questions, please press the button. I'm sorry, please go on, Ms. Kong. I hope the government can look at the comments, consolidate them, and give those comments some thought. Now, for teachers, at the hearing for teachers and school sponsoring bodies, a great comment was made about an exemption system. In this bill, in the preamble, it doesn't say that we should put the interest of the child first. So in the preamble of the bill, can we put that in? So this should be more than just about mandating reporting. We're not there to protect the professionals. We are there to protect children. So the government should consider this idea. And the exemption from reporting system, I looked at the cases elsewhere. Say in Australia, they have alternative reporting arrangements or alternative referral pathways. This point was raised at the public hearings. We heard about real cases. In very special cases, reporting the matter may leave the child worse off, so it's incriminating for the child. the child will be affected in adverse ways. So the government should do research into this matter. Don't just dismiss it right away. Think about why other places have alternative arrangements. The deputations made good points. At a school, there is a principal, the teachers, they all have a duty to report. The statutory duty is to report. One statutory defense is that once you report a matter, then you're good. But how do we delineate the responsibilities when you have more than one mandated reporter at the body? So someone at the bottom of the hierarchy tells their boss who will shoulder the greater part of the responsibility. The bill is silent on that. Now, serious harm. At different hearings, people wondered whether we can have clearer definitions of serious harm. Again, I looked at the laws in other countries. Say in New South Wales and of Australia, they have a definition of serious harm. So for us here, people raised cases, scenarios. Can we make the definition of serious harm clearer? It's a new bill, as the chairman just said, and this will have wide-ranging implications. Can we also include a review committee in the bill? We want to see children protected, but we want a new system that works. So the law should specify a certain body that will review the mechanism. Some deputations also said someone should be there to help the mandated reporters decide whether something should be reported. In Queensland, there's a reporting guide. It's online. The guide is there to help professionals. It's there to help the professionals whether to report a matter. It's a supportive system. It's an online decision support tool. The government should give this some thought. Thank you, Ms. Kong, for the ideas. Let's see if the government has any response. Thank you. Ms. Kong touched on several areas. I can address some points, and then my colleagues from other departments can address the other points. Ms. Kong's points involve the wording in the bill. We can get to that in greater detail as we come to the clause-by-clause scrutiny. Now, on the policy matters. Protecting the best interest of children. That's the whole point of this bill. On whether we put that in the long title or in the preamble, we can study the matter. On the reporting mechanism, the Education Bureau has commented on this. The reporting duty rests on individuals. Teachers, principals, when they come across suspected abuse, they have to report it at the individual level. But on the issue of several people reporting the same matter, we are in talks with the bodies on a possible guide to address this point. At the last hearing, the hospital authority said they have a computer system. So someone registers on the system and the matter is reported. On whether the same practice can be applied to schools, we can look at that at a later stage as we talk to individual institutions. Now, online reporters guide and decision tree, we can explore that idea later. We will set up a hotline for mandated reporters to file reports. Online reporting will be available, but on a decision tree to help reporters decide whether to report, we can look at that later to see if that will work. This is just about reporting. Subsequent investigation will not fall on the shoulders of the mandated reporters. That will fall to the Social Welfare Department, the police, the Education Bureau, where they will have interdepartmental collaboration. We now first want to have a protection web and then the other departments will take up the matter from there. So it's about reporting to prevent the abuse from going on. If the member has other questions, please raise that in the next turn. Before we get to Mr. Dennis Leung, since Mr. Leung submitted a letter, you can decide whether to discuss that letter. Thank you, Chairman. We had 3 deputational hearings. My focus is on the education sector. The education sector is in a unique position. The social welfare sector has social workers at schools. I made this point at the previous meeting. When students have issues, there's little liaison or engagement between teachers and social workers. A student may have personal issues, but then a form teacher or the other teachers involved may not know the situation. They don't know how's the follow-up going on. At schools, there are vaccination drives or health talks. There, healthcare workers are involved, and they may see bruises or other kinds of signs of injuries with children. And the health worker, upon seeing this, can report the matter to the school staff, the teachers, or principals. But then when someone outside the school comes to the school, should the social worker report the matter to their own superior? Should this matter also go to the principal? Say a healthcare worker sees this, should the healthcare worker report the matter to the school? This point wasn't explained clearly. That is, as far as the procedure and the workflow are confirmed, there's little clarity on this. Teachers and social workers, they want to see when they suspect abuse, how they should take the matter forward. They want to know what the procedure will be like. Instead of everyone just worrying about what to do, the education sector would like more clarity on this point. Now, on serious harm, the definition. It's said that people can report the matter even before it gets serious. But where do you draw the line as to what is serious harm, since now that we're talking about a mandatory reporting system? I know there will be guidelines, but then in assessing what is serious, we need a clearer line on where the line is drawn. And the Secretary, I want to clarify a point. Mr. Dennis Leung brought up whether the matter should be reported to the worker's superior. But as far as that bill is concerned, this is an individual responsibility because the mandated reporter is subject to regulation. There's a licensing system. The mandated reporter, upon seeing suspected abuse, should report the matter. There will be a reporting hotline. On whether this matter should be notified to the superior, it's a separate matter. The mandated reporter can choose whether to tell their superior. That's beyond the scope of the statutory duty. This duty is about reporting the abuse. So it's up to the mandated reporter as to whether they should report the abuse to the superior. But the duty is that the reporter, upon seeing possible abuse, should report the matter through the hotline or other channels that we will specify. Mr. Leung brought up a scenario of a health check or vaccination, and say a healthcare worker sees bruises or other wounds. Whether this should be reported depends on the circumstances. The bill states that the reporting should be done when there are reasonable suspicions. the education sector can provide us with more scenarios, and then the professional advisory panels can discuss those scenarios. We want to find a way that can address stakeholders' concerns and also protect children. The education sector gave us many queries, but few scenarios. So a vaccination drive can be a scenario, or a health talk given by a nurse can be a scenario. We would like the sector to give us scenarios. The practitioners will be more familiar with the possible scenarios. Give us the scenarios. Say a nurse comes across a student and sees wounds on the student's back. Should this matter be reported? This can be a scenario that can be provided to us, and then we can discuss whether there should be a mandated reporting scenario.
Dr. David Lam, thank you, Chair. 3 points on collecting scenarios. As far as I understand, the hospital authority said they got invitation from the administration to provide scenarios. However, other members of the industry seems not to have received such invitation. The public sector and the private sector may be facing very different circumstances. Apart from doctors and nurses, you have included dozens of professions into the list of mandated reporters. Say for dietitians or dental hygienists or radiographers, they may all be facing very different circumstances or scenarios. If you do not hold extensive consultation with all these professions, you will not be able to have a very comprehensive picture when you formulate the reporter's guide. I hope that you can hold extensive consultation. You collect views from both the public and private sector. That's my first point. Secondly, the hospital authority mentioned that if a suspected child abuse case is suspected or identified, there is a mechanism for them to report the case. However, should colleagues ask each other whether they have reported the case, you have to believe that the case has been reported by someone else and you can establish a defense. If you believe someone has already made a report, it should be made a defense, or it should be a defense. Third, the maximum penalty under the mandatory reporting mechanism is imprisonment. There are views that the penalty is too strict. I hope you can review that. Undersecretary. In relation to collection of views, I will invite the Health Bureau to tell you about the latest progress. Also, say someone has already made a report. Does that meet the requirement under the law? We can have a more detailed discussion about this when we come to the clause-by-clause scrutiny. We can look at how we can improve on our wording. Third, about the penalty. We are talking about the most serious situation here. I understand that members have different views on the level of penalty. We are talking about the most serious cases now. If reporters fail to make a report on very serious case, well, they will be subject to penalty. Is 3 months imprisonment too strict? Well, we don't want to make it too lenient, because we want to create a wide protection web for children. We hope that all mandated reporters will make a step or make an effort. I understand that this will increase the workload of mandated reporters. However, if we do not make a further step, we won't be able to create that safety net for children. We believe that a 3-month imprisonment will create a strong deterrent effect. I understand that some professionals may be subject to disqualification under the mechanism, but this is in the best interest of our children. This will help us identify suspected child abuse cases. We hope that this mechanism will protect children from persistent harm. I'll ask my colleague to tell you about the information we have collected. Thank you, Chair. I understand the concern of Dr. David Lim. We have written to over 10 healthcare organizations and bodies. There are 97 such groups and bodies, including organizations of healthcare professionals, as well as the healthcare professional bodies under the accredited register scheme. They also cover healthcare bodies set up by academic institutions and universities. We will continue to reach out to them. We understand that there are different types of professions under the healthcare sector. They are facing different working environments. When we formulate the guidelines, we will keep in mind that we have to take into account different scenarios. Have you talked to the optometrists? Yes, we did write to the relevant society and groups. Can you give us a list of who you have reached out to? Because there are people who tell me that they didn't get invitation from the government. We can talk about that after the meeting. I can also provide information to you that who told me they didn't get invitation. On the point about penalty, we have to look at penalty for perpetrators and mandated reporters separately. For mandated reporters, they have to go through hearings if they breach the rule. It may be too strict if they are subject to imprisonment. Under Secretary. When we come up with the penalty, we look at the other ordinances. Drug trafficking is different from abusing child. However, we are imposing a consistent penalty based on our comparison of different existing legislations. Reverend Peter Kuhn. Thank you, Chair. I've attended these meetings a number of times. For perpetrators or abusers, they may be identified. And when should mandated reporters make a report? Some mandated reporters may identify cases early. How long of a window are you allowing the mandated reporters to make a report? Some mandated reporters may think that they will have to keep all the information in a note. We are talking about quite a number of professionals included in the list of mandated reporters. Professionals in the healthcare sector may have different concerns compared with those in the education sector. No one wants children to be abused. There were discussions on how mandated reporters should report the case to, say, the management or their supervisors. it may be easier to prohibit people from obstructing mandated reporters to make a report. Well, there are different views about this. Also, we have to look at the wording of the bill. I hope the government can clarify on the wording, say what it means by real risk. How real should it be for us to consider it as a real risk? Say for medical practitioners, they may have a better idea of whether a child is at a real risk of suffering serious harm. However, we're talking about different professions here, so we have to have a clearer picture. Also, during closed-door meetings, the relevant sectors told me that there are sexual abuse cases. Say someone told me about a case and they don't want me to disclose the details. The person may really want to seek help, and he may not want you to deal with the case immediately. He just wants to tell you about his situation. How do you assess whether that person who seeks help from you is at real risk of suffering serious harm or will continue to suffer serious harm? We come up with this bill because we want to help our children. We don't want to trouble ourselves because we have this bill. Undersecretary. Under the bill, reasonable grounds will have to be established for a case to be substantiated or for a case to be reported. And we have the definition of material time in the bill. Chair, I'm not talking about cases that happened a long time ago. I'm talking about the window that you allow mandated reporters to make a report. And how do you consider who is the first one that comes to identify a case? Let's say a social worker has reasonable grounds to suspect that there is a case. Let's say you only see some kind of wound on a child's hand. Let's say if you may not have enough grounds to believe that the child is under or is suffering harm. Let's say if you notice a child is being beaten up by a rotten stick and you see wounds on the child and you see wounds that are different from what you first saw, then this is all based on the judgment of the relevant professionals. I believe that the professionals will be able to make a judgment after they attend the relevant training. We rely on their professional judgment. Thank you.
Chairman, will the term real risk be defined? When we come to the clause-by-clause scrutiny, I will shed further light on the term real risk. Ms. Connie Lam. Thank you, Chairman. We had several deputational hearings. I've also met with groups of healthcare workers and young people. I have some concerns about the bill. How is serious harm defined? This needs to be spelled out clearly in the bill. social welfare, healthcare, education sectors are involved. Social welfare sectors and the education sectors come into frequent contact with children. So, can this mechanism kick in phases? Pharmacists and optometrists told me, especially for pharmacists, they just give the medicine to the patient. There's little face to face contact with a child or a teenager. So those pharmacists wonder why they should have this duty. Can there be some sort of immunity for failure to report child abuse? Otherwise, these professionals are under immense stress. Optometrists also said that, say, at the eye center, a child comes here, they see something about the child or the parent, and the optometrist suspect abuse or neglect. But the optometrist has received no training in child abuse. The undersecretary told us about the professional advisory panels and focus groups. So how will the different professionals be trained? If you don't try out this mechanism in phases, and instead you roll out the reporting system in one go, that will create immense stress on different healthcare professionals. Now, on the definition of children, some laws define children as those under the age of 16, Offences Against a Person Ordinance, Protection of Children and Juveniles Ordinance. Some youth groups are saying, should we define a child as someone below the age of 15, 16, or another age? Or should we also hear the views of the child when the child tells you they think or they don't think they have been abused? Should we look at the laws elsewhere, or should we clearly define that concept here? Undersecretary. Just then, Mr. Ren Kong asked us about the object of this bill, and that is to protect the well-being of children. At the third public hearing, we said we cannot rely on just a helpline. We need a protection web instead of a helpline, so that when something goes wrong, there's a protection web to help them. For serious child abuse, different professionals may come into contact with children who are abused, and if we don't ask every professional who may come into contact with children to step up, then we cannot form this protection web. If every professional wants to see more leeway on their side, then we will have a protection web that will not work. Some professions, say chemists, lab workers, they just come across figures and blood specimens. But they may see something that shouldn't exist in the blood sample, say cocaine. Some may say this would take a doctor to tell something's wrong. But if a laboratory technologist sees this, this is not accessible to a social worker or a teacher, but the laboratory technologist comes across the information. Should this worker report the matter? Now, this can be further spelled out as well as the way to report this. We need everyone to step up and report the matter. We're not asking the professionals to investigate the matter. The statutory duty is for the professional to report the matter so that someone else can take the matter from there. The goal is to spot the cases that would otherwise have been off our radar. To create this protection web, we need everyone to make an effort. We need different professionals to take that step. We cannot rely on a single person. We need everyone involved. We need everyone to keep an eye out for child abuse from their respective perspective, and then we can create this culture of protecting children. I can see Ms. Connie Lam has noted concerns from sectors, but we just need everyone to make that step. Some years ago, we had a child abuse case leading to death. And then just some weeks ago, we had a case of a child taking dangerous drugs by mistake. I don't have the details of that case, but in that case, the teacher or the social worker wouldn't have been aware of it. It's more likely for a doctor or someone in the healthcare sector to be aware of that. Early identification will better protect children. Now, on the definition of children, whether it's we should set the age of 16 or 18 as the threshold or the upper age limit. We are looking at the comments from the Law Reform Commission and also from other sectors. Let's look at schools. It would make little sense for the law to cover someone at the age of 16 but not someone at the age of 17 or 18. The education sector told us setting the age of 18 would make the law easier to follow. There are trade-offs. Whichever age limit we adopt, the government will strike a balance. Members, if you wish to speak for a second round, please press the button. Mr. Lai Tong Kwok. Ms. Connie Lam raised the point about the age limit 16 or 18. I'm pleased to hear that the Undersecretary would look at the reports from the Law Reform Commission and the Law Society. In the government's reply, the government commented on the age element. But the response made no analysis of the comments submitted by the professional bodies. I would like the government to analyze the comments received. The government should tell us why the government picked 18 as the age limit. Walk us through the thought process. Just then, Ms. Doreen Kong mentioned Australia's laws. Australia has documents on this matter they have experience. In several states in Australia, the age limit varies from state to state, 16 to 18. It's the same country, but they adopt different age limits. There are reasons for that. So that will be helpful reference for us. We should learn about why Australia has different age limits, and that will help us arrive at our decision. I don't have any preconceived position myself on whether we should set the age limit at 16 or 18. What I would like to see is this. The government should consider this and then show us the pros and cons of the different options so that the Bills Committee will be aware of the thought process of the government. Now, serious harm. After several hearings, the community still struggles to make sense of the scope of the bill. As I see it, a mandated reporter in the course of work has reasonable grounds to suspect that a child has been suffering serious harm at the material time, and then this mechanism will be triggered. A few points here. First, serious harm. In other ordinances, there are clear definitions on serious harm. When you just look at this bill, people may wonder, is this a subjective assessment, an objective assessment? Does it involve good faith, possible belief, certainty in their belief? And people wonder what this means. If the government has in mind a certain threshold and spell this out in the bill, then everyone will get a clear sense of what it is all about. Say a professional sees something, they think the child may have been harmed, they report the matter even now. But the focus of this bill is on serious harm, and reporting is mandatory. So here, we will need a clearer legal definition of serious harm. Drawing the line is a policy matter. But the point is that this line needs to be drawn clearly so that people can tell when the legal or statutory duty kicks in. Serious harm is but one element. There is something else. The specified professional needs to have a reasonable ground to suspect child abuse. What do we mean by a reasonable ground to suspect? The words alone do not give us a clear picture. The Hong Kong Court of Final Appeal ruled in a case. It's HKSAR v. Pan Hong Fai. That case involves money laundering. The CFA made a ruling on the phrase reasonable ground. It's the opposite of what the lower court told us. So the term reasonable ground matters. The lower court back then said means would believe. That means someone who possibly believes count as a reasonable ground. But then the CFA says that's wrong. It could believe. It means a reasonable person having regard to the situation could believe. And that's what counts as reasonable ground to suspect. But here we have in this bill reasonable ground to suspect. Should we go on the test in the CFA case on Pan Hong Fai? So these phrases are of crucial importance. The groups that attended our public hearings couldn't make sense of the phrases, so they had all kinds of questions. So it's for the government to consider how to draw the line clearly. I have exceeded my time limit, so I will stop here. Undersecretary, a brief response, please. Chairman, several members commented on serious harm and reasonable ground to suspect. I was going to discuss that in greater detail during the clause-by-clause scrutiny, but since members brought this up, if you permit, Chairman, I want to spend more time on this phrase. Other members are still waiting to speak. Can you give us a brief response first? I will leave that to the clause-by-clause scrutiny. There I will go into the wording in greater detail. Mr. Michael Teen. Chairman. This bill is something that the Roundtable and I were asking Mrs. Carrie Lam to launch. At first, Mrs. Lam refused, but then a few months later, she agreed to have this bill. We pushed for this bill for a reason. We heard different views. Those are well-justified views. Now, serious harm, we set the bar high so that we don't have indiscriminate reporting. On the age limit, some people wonder whether we should set it at 16, 17, or 18. we can consider where we can set the age limit. And third, should we cover the 25 professions? Some professions sound far-fetched, others sound more reasonable. I can entertain restricting the scope. Some people are bound to be unhappy wherever you draw the line. Once you offer greater clarity, you are lowering the bar. So now I come to the penalty. Back in 2021, at a meeting of the panel on welfare, a government paper said that they looked at Australia and the US, the penalties there of 2 or 3 years, and finally the government decided on 3 years. In 2022, the government adopted a different principle. The government looked at other cases instead, dangerous drugs ordinance, and the laws on recovering proceeds of crime, and then the criminal procedures ordinance. The maximum penalty fell from 3 years of jail terms to 3 months of imprisonment. So at the first meeting in July this year, I was surprised. Chairman, you put the same question. What other similar ordinances were looked at? The government couldn't give us an answer and could only give us a response after the meeting. So even the government struggled to provide a basis of comparison. So they want to set the penalty level at 3 months and leave everything else later. So here are my 3 points. Failure to report. We are comparing the failure to report with child abuse itself and other offenses. Child abuse leading to deaths is put at the same level as drug trafficking, but I take issue with that. The government says it's 3 months in jail for the failure to report any offense. I take issue with that. Now, the professionals, there will be training. They have a duty to report child abuse. But the other offenses of failure to report apply to the general public. Say a wife may not be aware of her husband engaging in drug trafficking. Are the penalties for the failure to report under other offenses too lenient? These penalty offenses were set in the 1970s and 80s. Can the DOJ look at the failure to report offenses under other laws? Are those too lenient? Should we look at the penalties set decades ago as the benchmark? So does that mean that for all offenses involving the failure to report will lead to just 3 months imprisonment down the road? The Undersecretary told us a single day of jail terms for professionals is something huge. But what does that mean for the general public? Professionals are the subject of high social expectations. But then in 2 cases, judges are saying that we should not privilege someone for being professionals. So we should have penalties, harsher penalties for professionals. But then when you look at maximum penalties, the judges don't always hand down the highest penalty. Another secretary told us for flouting the building inspection orders, courts don't always hand down the maximum penalty. So when you have a maximum penalty of 3 months, the actual sentence may be just a few days. The government gave us 3 years as the maximum penalty. Now it's down to 3 months. I asked for the maximum penalty of 1 year, so that then the judge may hand down a few weeks to a month in jail. When you set the maximum penalty at 3 months, the actual sentence may be just community service orders. So I take issue with the maximum penalty here. I wrote a book on children, so I should be speaking up for them. Children talk to me.
Mr. Ho, we included these professions, but basically everyone can make a report. We target these professionals because we can provide training to them. We think it makes sense for these professionals to make a report. We cannot mandate all citizens in Hong Kong to make reports. How come the penalty level is so low? Lowest among all countries in the world. Well, it's not the lowest among all the countries in the world. I'm talking about the same offense in other countries. I'm not talking about failure to report on other offenses. Well, there are different penalty levels in different countries. In Australia, the fine is 10,000 Australian dollars as well as 2 to 3 years of imprisonment. For the US is 300 US dollars for the fine and 5 years imprisonment. In California is 6 months imprisonment and 1,000 US dollars of fine. I'm talking about the maximum penalty here. Don't tell me about the lowest penalty. Which countries impose a stricter penalty than 3-month imprisonment proposed here? Say in South Australia, the maximum penalty is 2 years of jail term. For Queensland, it's 3 years of jail terms. In the US, the maximum penalty is 5 years of imprisonment. As mentioned in California, the jail term, the maximum jail term is 6 months. Which countries impose a penalty level lower than 3 months of imprisonment? Undersecretary, can you tell us which countries impose a more lenient penalty as proposed in the bill here? Well, we look at other local legislation. Chair, I rest my case. There's no single country in the world that imposes a penalty level that's lower than a 3-month imprisonment. Mr. Michael Teen's view is clear. I believe the government will take that into consideration. It has to do with the policy. Now let me give you an update on the meeting, including myself, Ms. Elizabeth Kwok, Mr. Chu Kwok Keung, and myself will speak for the first round. Ms. Elizabeth Kwok. Thank you, Chair. We have been discussing child protection for a long time. When I first joined the Legislative Council, that was 11 years ago, we were already discussing how to protect our children. Back then, the government couldn't roll out the bill because the government was met with a lot of objections. We had opposing views from professionals from different sectors. Professionals fear that they would breach the law inadvertently. We have been wanting to legislate to protect our children. Every year there are failures of reporting child abuse cases. We cannot neglect this situation. Professionals, including those at schools, have failed to report on child abuse cases, healthcare professionals as well. That's why we've been pushing for legislations. I wasn't able to attend the public hearings, but I have listened to people's views. My position is this. We have very good professionals in Hong Kong. With sufficient guidelines and training, I believe our professionals will be able to make a judgment on how to protect our children. They will be able to make a judgment on whether a child is subject to any risk or crisis. Some professionals may wonder why the responsibility rests on them. However, I'd like to stress that it is the responsibility of all of us to protect our children. The government included these professions in the bill because they think that these professionals concerned come into frequent contact with our children. But if you ask me, I think all of us are responsible for protecting our children, not just the professionals. I understand people's concerns. We are bound to face difficulties when we first implement the ordinance. There may be struggles. There may be challenges. As long as you suspect that there is a case, well, you don't have to confirm whether a child is subject to abuse. If you find anything abnormal, if you find unusual wounds on a child, then you should make a report. It doesn't matter whether you report the case to your supervisor or not. Once the guidelines are available, then everything becomes clear. This should not be a concern. We're still discussing who should be responsible for making a report, and I think we are falling behind if we're still concentrating on these issues. My suggestion is that the government should have further discussions with the relevant groups and bodies and tell them what the guidelines are. You should come up with a timetable so that the relevant sectors know when they'll get the support and they don't have to worry about breaching the law inadvertently. There are discussions about how we should define what a child is and what serious harm means, etc. How do we define a child? In different legislations, we have different age limit. How can we include teenagers or senior secondary students? I believe the government should review the definition. Say we set the age limit at 18. 18 is the age limit proposed by the government now. I think it's acceptable. I don't have any issues with whether the age limit should be 16 or 18. On the issue of level of penalty, some professionals think that the penalty proposed is too harsh. Well, my view is that it's too lenient. I think we should strike a balance. I want to make a point about sexual offenses. I have some concerns. I have come across some sexual offense cases. Sexual assault is different from physical assault. It can create serious harm on a child. I'm worried that people may not seek help if they are sexually abused. I wonder how we can encourage victims to seek help. Under what circumstances should people make a report? I suggest the government talk to Rain Lily or other organizations on how we should draw a line. Some victims of sex abuse, they are subject to harm persistently, but they do not seek help.
Sexual assault cases are the most complex kind. Some are assaulted as a child, others assaulted in the teenage years. Undersecretary, indeed, this is a complex bill, but we have to go ahead with this. After the Gazetted of the bill, or in that passage of the bill, there will be 18 months of transitional period. There will be training. There will be amendments to the professional code of the professions involved. Once this bill is passed and gazetted, we will move on to the next stage. We note the members' comment. We will continue to work on this. Indeed, sexual assault present difficulties. Some concerned groups have made comments. Now, what if you have a failure to report and then the assault continues? There's a provision in the bill. Say a social worker or another professional. If they see a need to delay the reporting, they can do this. It's written into the law. So say the professional will first have to calm the victim down and help the victim with family relations. This will take more than just a few days. But there is a provision for the professional to make the preparations. We will continue to engage with the stakeholders. Indeed, we have the same concern, but at the end of the day, it's about protecting the children. Mr. Chu Kwok-kang. Thank you. I support Ms. Kong's proposal about setting up a hotline so that professionals can call the hotline for inquiries. Each case is unique. The professionals need guidance on what to report. Training should be made available to every teacher or staff member involved. But then principals, discipline masters, and social workers should receive training in greater depth so that they can find out more about the bill. Now, for the disciplinary masters, there is no mandatory requirement that they undergo certain training. There are disciplinary training courses. Teachers can become disciplinary masters even without undergoing the training. That's wrong, as I see it. Can we make it a requirement? So for disciplinary masters who want to seek promotion, they have to get training on mandatory reporting of child abuse. Can we also create mandatory training for the positions I mentioned? Now, for round-the-clock support hotline, you need social workers. Every primary and secondary school has the funding for a social worker. When a school has special cases for inquiries, and this superintendent can play their role. I don't know about the qualifications for the role of a superintendent. Maybe a senior social worker would do. But for someone to become a professional superintendent, there has to be professional training to go with it. I hope the government can step up training for social workers who serve as superintendents. That way they can help make professional judgments. Chairman, my colleague from the Education Bureau can comment on the point about education. Now, we will have a round-the-clock hotline. The reporting hotline will also be running 24/7. people may have inquiries. There will be a separate hotline to address those inquiries. We're still studying whether we make that a round-the-clock hotline. We will see if we can have more resources to make the inquiries hotline a round-the-clock hotline. But for the reporting hotline, this will be a round-the-clock hotline. Now, my colleague can tell us more about training in the education sector. Thank you. The member raised a few points about training for people at schools, for teachers in different positions. There will be targeted training to help them learn about their respective roles after this bill is passed and the arrangements to go with it. Our goal is for teachers in different positions to know the workflow involved and how to identify students who need attention early on. Now, on promoting teachers, the Education Bureau has requirements for teachers seeking promotion. There will be mandatory training on leadership, the teachers' professional roles, etc. We also encourage teachers to go for training related to their roles, say disciplinary masters or counseling masters. The teachers are required to receive training related to their work so that they can play the professional roles effectively. Chairman, a follow-up. The government said they would encourage teachers to take the training, so the teacher can choose not to do the training. Some teachers become disciplinary masters without having gone through the training. So they don't know much about the cases they are supposed to handle. Making the training mandatory, which includes the bill on mandatory reporting of child abuse, will that lead to better disciplinary masters? We note the comment and we will pass on the message to the colleagues involved. The last member to speak for the first round will be me. Members, if you have follow-up questions, you can speak for a second round, 4 minutes for each member. Some questions for you, Undersecretary. The bill says that it's there to protect the child's best interest. This is core to the bill. Are the wishes of the child part of the consideration? Say in a sexual assault case, the child does not want to see the case reported. The professional follows the child's wish. Is that a defense or something allowed in the bill? Or if it's a case of neglect, the child may see that's just a way of parenting. They don't want to see a broken family. Where in the bill does it say that the wishes of a child are respected? Or is the bill drafted in such a way that the reporting goes ahead despite the wishes of the child? The second question, this may be for the Undersecretary or maybe for the Department of Justice as well. Some people struggle to make sense of the terms material time, serious harm, real risk, and the child's best interest. These phrases are about principles, but then different courts and judges may read those same phrases differently. People would like to see greater clarity with the provisions, so that may involve amendments. Will that work better? Or is the government confident enough with the provisions as they are? Is the government confident that the guidelines to be drawn up will be clear enough and the professionals will be able to follow them and the court can follow that? So which will work better, amendment or the guidelines? Now, as we scrutinize the bill, we've got the attention from the professionals. I hope that we have achieved a result of encouraging professionals to report suspected child abuse. Participation matters. 78 deputations attended our public hearings. Has every one of them received the consultation papers mentioned by Mr. Ho Kai-ming? Has every one of them got the consultation papers? And for the 25 professions, has the government engaged with the bodies involving all 25 professions, involving midwives, dietitians, radiologists, and lab technologists? The relevant bureaus will comment on their respective areas. Now, on the wishes of the child. This is a tough balancing act. We will consider the child's wishes. That's why the bill says that when the social worker or the professional involved can delay reporting after taking into account factors including the child's wishes. But whether the professional should not report the case simply based on the child's wishes alone, I have reservations. The child makes the request based on their experience and their worldview. But for an abused child who has this request due to the experience, what we should do is to prevent further abuses. We can show the child there are other options. So we allow delays in reporting. The professional talks to the child, the professional tells the child there are other options. So that's our position on this matter. I will now ask my other colleagues to respond to the other points. Chairman, we have engaged with most of the groups. I will have to double check the list to see if we have left out a couple of them. We looked at the attendance list. We have asked them to provide us with scenarios. Other officials, groups attended the last hearing. Others wrote to us. We have given them the consultation papers. We are double checking the list to see if we have left out anybody. We try to engage with them. We have reached out to 97 bodies.
Last question from me that has not been responded to. On the specific wording that we looked at, are you going to deal with them in the guidelines or are you going to make amendments? I think we'll wait until we come to the clause-by-clause examination to make a decision. Ms. Lillian Kwok. Thank you, Chair. I was away, so I may ask questions that have already been raised. I wonder if the government can provide documents about the difference of the penalty proposed here as well as the penalty from other countries. I'd like to have more information about that. Second, about definition of professionals. I want to compare the scope of professionals included in this bill and that in other countries. Thirdly, under the proposed reporting mechanism, reporters can make a report to the Social Welfare Department and the police. If the bill is passed, do reporters make a report only to the Social Welfare Department, or do they also have to do so with the police? Or do they have to report to both? How are you going to coordinate the work? I got views that the police may get a report and they have to refer the case to the Social Welfare Department, and there's a time lag in between. Undersecretary. Currently, we have a interdepartmental system to deal with the cases. The SWD and the police have an internal mechanism to deal with such cases. There may be a little time lag in terms of the administrative procedure. Both the SWD and the police would know if there is a case. In the future, when the bill is passed, we'll follow a similar mechanism or procedure. As for practices of other countries, I responded to Mr. Michael Teen's similar question just now about the practices in other jurisdictions. Some jurisdictions adopt a more stringent penalty system. We have drawn reference to practices overseas, and we've come up with the penalty level we propose now. Can the government provide the information I asked for? I want to compare the situation in other countries and the local situation here. That includes information about the scope of professions included, as well as the differences in penalty level. I believe you have already done the research, so it should not be very difficult for the administration to provide such information. We will provide that information in the next meeting. Also, I was saying that there may be a delay or a time lag in the procedure. I want to know your current practice in handling cases. Secondly, in the future, will the mandated reporter only have to make a report to either the SWD or the police? Or will they have to report to both? Under what circumstances will the reporter have to make a report to the police? I've come across a girl who had wounds, serious wounds on her body. Well, in such case, I'll have to make a report to the police immediately. The SWD does not run round the clock, so mandated reporters may not be able to make a report immediately to the SWD. SWD. For serious child abuse cases, currently, we follow the same system as that proposed in the bill. The SWD and the police will have knowledge about each case. The police will handle cases that have criminal elements in it. For the SWD, if they find that child protection support will have to be given to prevent further abuses on the child concerned, then the SWD will intervene. For some cases, they may be mild cases. After the police makes investigation, they may think that no follow-up actions need to be carried out, and they would not report the case to the SWD. For serious child abuse cases, the SWD and the police will both have knowledge on the case, and they will work on the case together. Sorry, Chair. Does that mean the mandated reporter will only have to make a report to either the SWD and the police? The government will have to clarify on that because the mandated reporter would not want to leave out any of the party involved. The mandated reporter can choose to make a report to the SWD and the police. There is an internal reporting mechanism among the different departments. Well, you have to spell out who the mandated reporters have to report to in your guidelines. 4 members have pressed the request to speak button for the second round. I understand that Mr. Lighton Kwok has other engagements, so I'll have him to put the questions first. There are concerns about Clause 5. It provides for the defenses for mandated reporters. I suggest that you adjust your wording there. You include provisions about prosecution first in this part of the bill. It's painful if a professional have to go through legal proceedings. Why don't you say explicitly here under what circumstances a specified professional would not breach the law? Then the burden would rest on the agency that is in charge of prosecution to decide whether the specified professional contravenes the law or not. If a professional had made a report before the time of the alleged contravention, then he would have a defense. If someone had made a report already, then you would not have to worry about whether to prosecute that person or not. I think you have to amend the wording here or adjust the way you phrase the provisions here to alleviate the concerns of the specified professionals. You don't have to change the content of the provisions, you just have to adjust the order of the paragraphs, perhaps. Under Secretary, I share the same view with Mr. Lai in terms of how we should adjust the wording. We can wait until we come to the clause-by-clause examination to look at how we can make the amendments. We want to prevent specified professionals from having to go through unnecessary proceedings, so we'll look at the wording after the meeting. Department of Justice. According to the prosecution code, when the prosecutor decides whether to initiate a prosecution, he will have to consider the evidence available. When a prosecutor decides whether to prosecute someone, he will take into consideration all the defenses. If a case is taken to court, then it is the defendant that will have to adduce evidence. I believe the DOJ has answered the question. I hope the government can consider this. We should not put a burden on the professionals. Ms. Doreen Kong, 4 minutes. I hope the government can study the wording or definition of serious harm and real risk. This affects the thresholds for reporting. We have to consider the degree of harm and the degree for suspicion. On reporting for child abuse, a lot of countries have conducted relevant studies. We have to look at the degree of harm and the degree of suspicion. They are complicated matters. I understand that the government drew reference from the law of the New South Wales. Professionals are perplexed about the bill. You look at the clause 4 bracket 1 of the bill. You have to look at the risk as well as the serious harm. Should the reporter focus on the risk or the harm then? If you ask me, I'm not sure after reading the bill. Since day one, I have mentioned that you should not cover such a complicated bill with or such complicated content with just 8 pages. We have to know how we strike a balance between considering serious harm and real risk. In other countries, we see situations with over-reporting. Has the government thought about when to conduct evaluation on the legislation? If many reports arise, we may not have enough resources to handle the reports. We have to think about when to conduct evaluation. What are the good indicators? In other countries, when they conduct evaluation, they look at the good indicators. In the UK, there have been discussions about the ethical consideration of mandated reporters because they have to keep things confidential. Does the bill go against the ethical code of professionals? In the US, when they deal with sexual abuse cases, they perhaps put confidentiality in the second priority. We have to make sure the bill is clear. This is because studies show that clarity of the bill would affect directly the level of reporting and the quality of the reports made. We have to ensure clear and unambiguous provisions in the bill. Lastly, I want to point out that in the UK, there was a report published in August about sexual abuse. They find that for sexual abuse cases, there should be a separate reporting benchmark. I hope the government will look at the latest consultation papers published in August in the UK. They've looked at practices all around the world. They mentioned that for reporting of sexual abuse, there must be measurable outcome and clear definitions. Also, within the governments, there should be impact assessments. This is because they want to assess the impacts on the government system. Also, they suggest that there should be children's rights assessment studies. I hope that the government can study the report made by the UK in August 2023 to see if we can draw any reference from that.
I thank Ms. Kong for raising the examples of other jurisdictions. I will consult the report Ms. Kong refers to. If I get a chance, there will be 41 permanent posts to enhance our enforcement and support capacity. We do expect a rise in reports of child abuse, but it's hard to tell how the extent of the rise. If there's fewer abuse, and we will see a smaller rise. Once this bill takes effect, that it's enacted and takes effect, and then we will keep an eye on the situation. Undersecretary, you need the people, but you also have to have the system. The reporting system will be up and running in 2025. Ms. Kong raised a number of points. If Ms. Kong, you can give us a written form of the points you raised, that would be good for everyone to refer to. Mr. Dennis Leung. Say at the school setting, a teacher suspects child abuse. The teacher has to go through the usual procedure. That means talking to other colleagues. A suspected child abuse happens. A teacher has to make a professional judgment. But the teacher may not come into contact with the student all that often. Maybe the form teacher or the counseling teacher knows better. The government says, report it if you have suspicions. Professionals shouldn't be reporting just because they worry about breaching the law. They are there to get things right. Let's leave aside the statutory requirement. Will there be more support from the Education Bureau and the Social Welfare Department for schools to do better at reporting? Once the new law takes effect, the schools have to consider how to get things right. It should not be just about avoiding criminal liability. The principal may want the teacher to let them know before reporting. When you have a child abuse case, it should be more than just about reporting. The question is, what's next? What further steps should be taken to protect the child involved? There is follow-up work required of schools so that teachers get things right and can proceed with their work with peace of mind. Chairman, let's see if the Social Welfare Department and the Education Bureau can offer a response. Thank you. We have mechanisms and procedures for different professionals that includes teachers and social workers to follow up on cases of child abuse. As the Undersecretary said, there will be training for mandated reporters. there are two levels. At one level, there will be basics on handling child abuse cases. Now, we don't have a mandatory reporting system yet. Not every professional who comes into contact with children knows the basics. So we want to start with the level 1 training. We give the professionals the basic knowledge. Level 2 training focuses on reporting. Once the bill is passed and we have the detailed provisions, and then we have the framework of the reporter's guide. For each profession, we will provide the appropriate training over to the Education Bureau. And in response, for schools go by the Protecting Children from Maltreatment Procedural Guide for Multidisciplinary Cooperation. When students are subject to different forms of abuse or maltreatment, schools report the matter and follow up. Once we have the mandatory reporting regime, the existing reporting and follow-up mechanism stays the same. We will update the guidelines. We will hold briefing for the education sector. There will be training so that we can let teachers and others in the education sector know the new arrangements. They will learn about the follow-up work under the new arrangement. Ms. Connie Lam, 4 minutes. Thank you. Just then, Mr. Ho Kai-ming said different professionals have a duty in the mandatory reporting regime. I don't have any issue with that, but we have to be mindful of the strengths of different professionals. For some supplementary medical professionals, such as optometrists, pharmacists, and midwives, they need a large amount of training before they can tell serious harm has taken place and they have to report the matter. Otherwise, they lose their jobs. And for midwives in particular, say a parent slaps a child or pats on the bottom of the child, what's the role of a midwife in that scenario? Midwives are found at maternity and children's health clinics. They don't have a particularly big role in the process. Why not leave them out of the professions? It's hard to convince them that they should be part of the regime. Once this bill is passed, it will have wide implications: education, social welfare, and healthcare. People are panicking. They talk about this bill in the open and in private. Can the government give us a response? Thank you. We selected these professionals. We will provide training. Starting from the first quarter next year, we will start with the Module 1 training for the professionals. That will cover the background. Module 2 will cover the provisions. That will happen after the bill is passed. We will start with the generic training. And for the supplementary medical professions, my colleague from the Health Bureau can give us more details. For each medical profession, they focus on a particular area. We want to have professionals looking at things from different perspectives, and then we create this wide protection web. We have to be careful when we think about whether to leave out a certain profession. Chairman, one comment. Optometrists' bodies have told us they agree that we should go ahead with the bill. But then for midwives, I have grave doubt. Health Bureau, please. Ms. Connie Lam has told us about the issue about midwives. They work at maternal and child health clinics. They provide advice on raising a child. For midwives, they are also nurses. And by virtue of being nurses, they are part of the MRR. But I can see where Ms. Lam is coming from. We can see the concerns from the sector. It's about the reasonableness. The professional acts in the capacity and comes into knowledge of a certain fact. That's why we provide statutory defenses. As the Undersecretary said, we are working on the reporter's guide. We note the sector's views. At medical premises, children often receive services. Indeed, some professionals come into contact with children on rare occasions. But the principle is to have this comprehensive protection web, and that justifies putting all medical professionals there. So we will provide reporter's guide and we will provide adequate training to address their concerns. A follow-up question, because a question wasn't answered in the first round. Can we have this bill kick in different phases for different professions, just like what we did with other bills? Undersecretary. Chairman, it's hard to have the same protection web kick in at different stages because that will mean some cases will fall through the cracks. There will be a transitional period of 18 months for preparation, but the protection web will kick in at the same time. There will be enough time for preparations, but the web will kick in at one point. Dr. Teck Chi-yun and Mr. Dennis Leung both wrote to the Bills Committee on the policy matters and the law. Since Dr. Teck is not here, I will invite Mr. Dennis Leung to walk us through his paper or letter. We have just 1 minute for the letter. Thank you, Chairman. Clause 5, reporting. Clause 9, no inhibiting or obstructing of reporting. Clause 11, no disclosure of the identity of a mandated reporter. All three clauses carry the same penalty, a fine at level 5 and 3 months of jail terms. But the three offenses vary in severity. So my question is, for clauses 9 and 11, should we have stiffer penalties to show those offenses are more serious? Thank you. A simple response from the government, please. Chairman, we note Mr. Leung's comment. We align the penalty levels for clauses 9, 11, and with level 4. Of course, sometimes it may be a careless mistake. But those offenses have implications for the integrity of the system. Someone flouting clause 9 will be undermining the system. I will extend the meeting for 15 minutes. Now, some housekeeping matters. We will work with the government to set up a time for the 6th meeting of this Bills Committee in January next year. And if members have no objection, we will get into the clause-by-clause scrutiny at the next meeting. But I have to ensure that before the next meeting, based on the meeting today and the 78 bodies and the 52 written submissions, the government needs to give us a written response to all the views given today and the previous submissions. Members have also asked for supplementary information and clarifications and also comparisons today. I need to ensure that we have an informed discussion. We need all the information, and then we proceed on to the clause-by-clause scrutiny. Do we all agree on this? If we are, then I will adjourn the meeting here. Let's hope that in 2024 we can start the clause-by-clause scrutiny. Thank you.